Due Process, recipient of 6 Mid-Atlantic Emmy Awards.
Painful, very, very painful. You have to do a lot of studying, a lot of research, a lot of reading up on things.
And even then, you could be in trouble if you try to do what this woman does. Despite numerous complicated lawsuits, she goes it alone, without a lawyer, pro se. A good alternative to attorney's fees or a penny-wise mistake. Representing yourself. Up next on this edition of Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual.
At some point in their lives, most people will wind up in a courtroom, and most of them will go with a lawyer. But there is a growing trend to try to do it yourself. Fight your own legal battles. I'm Raymond Brown, and on this edition of Due Process, the risks and rewards of going pro se, representing yourself. We'll talk to the founder of a national organization based here in New Jersey that devotes itself to the art of pro se, to a Seton Hall law professor whose clinic helps pro ses, and to a former public defender who says the pro se litigant may have a fool for a client. But first, here's Sandy King with a look at the widening world of litigants determined to go it alone.
Raymond, no one knows exactly how many they are, but court watchers agree that their number is growing. There are said to be at least 85,000 of them every year, and it's having an impact on New Jersey courts. Detractors say they further slow an already backlogged system, so much so that the Administrative Office of the courts has felt compelled to give them a hand to offer some assistance as they try to work their way through a complex, difficult system, one that has its own rules, its own potential pitfalls, even its own language. But beyond the challenge of navigating the system, of following and understanding the rules, there's a bigger question. Can their self-representation really be effective? It's a question we took to a litigant in numerous lawsuits who's lost count of all the times that she's been in court pro se.
Sometimes you prevail and sometimes you don't. Like the one we're doing today is just for enforcement of litigants' rights and to, maintain alimony and child support.
So Pam Chevet is on her way to court. She has the briefcase, the papers, the preparation. What she doesn't have is the lawyer. Not since her $250,000 divorce.
I did have attorneys in the divorce case, and my divorce cost approximately $242,000, and I was basically wiped out from that.
But the lawsuits and the countless legal files were just beginning to pile up. Fallout from an ugly breakup and a husband she says left her on the spot.
So when all these other lawsuits came up, I had to represent myself. Otherwise, I was going to have all these judgments against me from the different banks and the like.
So Pam joined the growing ranks of those who go it alone, fight their own legal battles.
And you're representing yourself, Ms. Castaldi?
Yes.
And you're representing yourself, Mr. Duff?
Yes.
The term is pro se.
Pro se is the Latin, which means for self. When you go to court and you're representing yourself, you're now a pro se.
And for true believers like Carl Frederick, that's almost a religious term. Carl heads the New Jersey-based American Pro Se, a volunteer group that helps self-representers do it right.
The problem is that the court has become very complex with rules. Most of those rules are very good rules and necessary, but if you don't know there's a rule book, and if you don't know how the system works, you're going to get washed out by the lawyer adversary on the other side long before you'll get anywhere, and You just lose on technicalities.
All right. Are you representing yourself and acting as your own attorney?
And today, just on the internet, we're helping about 600 people a week.
Helping them, and not only in small claims court, where going pro se is an everyday event, where judges are used to explaining the law to pro ses.
Now, he has pointed out, much better than yourself, I may say, so that's why his testimony is much more persuasive, that is indeed a left-window regulator.
But the pro ses who need the most help are the ones with more at stake. In Pam Chevet's case, millions more. And the bigger the case, the more complex, the more difficult.
Painful, very, very painful. You have to do a lot of studying, a lot of research, a lot of reading up on things. When I first went to American Pro Se, I couldn't even use a computer. So I not only had to study up on how to represent myself in court, but I also had to learn how to use a computer so I could do the documents.
And preparing the documents is no easy job. In fact, that's what's at the heart of We the People, a business designed to help pro ses with 85 franchises across the country.
We are a legal document processing service. We represent people that we do documents for people that represent themselves.
Represent themselves in the kind of routine cases that can carry a hefty lawyer's bill.
Be it a divorce, be it a bankruptcy, be it a conservatorship, an adoption complaint for divorce. Okay. Seems to be all in order.
What we try to emphasize is that people know that it's their constitutional right to represent themselves at court. Now, we are also filling a gap here for people who do not qualify for legal aid, but also on the other hand side, also for people who do not want to pay the high fees of an attorney.
But while the We the People business sticks to the simple stuff, the American Pro Se volunteers
Nobody is paid a dime. Nobody's even reimbursed.
set no such limits, not even on whether the case is civil or criminal. They claim for those members willing to do the hard work,
21 all-nighters so far this year.
there is a solid success rate, as high as 80%. Still, most pro ses really are alone, without support of any kind, feeling their way through a foreign world with a foreign language, and a judge who may just run short on patience.
Please, I hope he doesn't say that we didn't want to.
You don't suggest it, and you won't say it.
I hope he don't say it.
Case is over. What we learn in law school is quit when you're ahead. You got the money, he got the time. Thank you. Off record.
And increasingly, the pro se litigants are not confined to landlord-tenant or small claims. We've all seen the stories of criminal defendants who've insisted on their right to represent themselves. But even more common are the civil litigants, sometimes involved in complex cases, who believe they can do it without a lawyer. And in addition to turning to a business like We the People or to a volunteer group like American Pro Se, they can turn to the courts. There's a state judiciary website that offers forms to download and even some general legal advice. That website, www.judiciary.state.nj.us. In some of the busier courts, there's even a kind of ombudsman on hand to answer pro se questions. And given the drag that pro ses can be on the courts, it's not just altruistic. Raymond, it may be a kind of judicial self-defense.
And that's where we'll pick it up when we come back with some widely divergent views on pro se. Can you really do without a lawyer? Stay with us.
There's an old saying, anybody that's his own lawyer is a fool for a lawyer. It's probably right.
I would probably talk too much and get off the subject.
Sometimes you say things you shouldn't say. So I really do think you need legal representation so that you don't, for lack of better words, put your foot in your mouth and say the wrong things.
Civilly, I would represent myself pro se, possibly. And criminally, I really think it depends on the offense.
Not knowing the law and all the ins and outs, I think you're better represented by a lawyer.
I don't know enough of the legal system, and I think I would get myself into hot water.
No, me. I need a lawyer.
So they really didn't like the idea. One lunch hour in Livingston where we took that decidedly unscientific survey, but then they never talked to Carl Friedrich, CEO of American Pro Se, a volunteer organization that helps pro se litigants work their way through the legal labyrinth. They might get an amen, though, from Robert Tarver, a defense attorney in Toms River and the former chief public defender in Ocean County. He thinks going pro se is most likely a mistake. And we'll get yet another view from our Newark studio from Seton Hall Law Associate Professor John Romberg. He heads the school's Impact Litigation Clinic, which, among other things, gives assistance to pro ses. Welcome to all of you.
Thanks, Ray.
Carl, let me start with you. I think that when we talk to people, as we did in anticipation of this show about pro se, most people think of Colin Ferguson, the man who was convicted of the killings on the Long Island Railroad, but who represented himself in a highly watched and televised program. But in fact, there is a different aspect of pro se litigation that you focus on, and it's growing, and it has much to do with civil matters.
Well, yes, because of course people imagine there's that pro bono attorney out there, and attorneys have to pay the bills and eat, and they can't be pro bono really.
By pro bono you mean free?
Free.
Okay. Let me ask you this. What's been the reason for the increase in pro se litigation in recent times?
Oh, it's really very simple. People don't have the money, and the cost of being a lawyer is going up. It costs them more to go to law school, so they have more loans to pay off. It costs them more for legal materials and all the other expenses. So what can you do? I mean, if you don't have the money for a retainer, you certainly shouldn't lose by default. I mean, you ought to at least try and see if you can defend yourself.
Rob, what do you think in terms of effectiveness? Because even if it is, the process is driven by economics, one of the real tests of any kind of litigation is, are people effectively represented?
Precisely.
Do you think pro se litigants have a chance in most cases to be effective?
No, Ray, let me tell you, this is not your mother and father's old criminal justice system. The laws have changed. They've gotten to be so much more complex. I mean, you know, your legislators have passed all these new regulations, mandatory minimums, best practices in New Jersey, which is meant to speed up the system. It's hard enough for lawyers to be able to deal with those different problems.
Best practices is a civil idea.
Yes.
So you think that even in the civil realm that there's a tendency for pro se litigants not to get the best representation?
Oh, I think very clearly. I think it's more stark in the civil world. At least in the criminal side, you've got the Sixth Amendment, which guarantees you counsel if you want it. There is no counterpart on the civil side. That means that if you can't afford a lawyer, in many cases, you're just out of luck.
Let me pick up on the implications of something both you and Carl have said. Professor, we have a society where there is legal aid available for some kinds of litigation for the very poor. But above that, there seems to be a huge gap. Is this a problem that ought to be looked at in terms of seeking some solutions other than or in addition to opportunities for pro se litigation?
Well, first of all, I think it's important to recognize that even those who financially qualify for legal aid or legal services, which is you have to earn a very small income to be eligible. Even in New Jersey, which is a lot more responsible about providing legal services to indigent people in civil matters, only about 1/6 of them are able to procure representation by a legal services group or by Seton Hall Law School's clinics.
So then most people can't avail themselves of legal services. The question is, what else should be available in your view? Is pro se the solution, or do you think we ought to be talking about other kinds of resources being available?
Well, I think the problem is even worse than it might seem, and I think in terms of the solution, I do think that part of the solution is increasing the number of resources for pro se litigants and enabling them to have an effective chance. Part of the solution is coming up with ways to fund lawyers who are able to represent these clients, because I think I largely agree with Robert Tarver. It's very difficult for pro se litigants to have a reasonable chance in the courtroom.
Now, Seton Hall, which is a private institution, does provide support, but you think this should be available on a wide-scale public basis then?
Absolutely. Without public funding of legal services for poor people, there's no realistic chance for the vast majority of people who need legal representation to be able to get it.
Now, Carl, I know that you provide support for pro se litigants, but let me ask you this question. Robert Tarver implied that there was a significant drop-off in the quality of representation when a person represents themselves. I think that's a question that we got to address. What do you
Well,
think?
I think we go to our statement that I've made many times, which is there are two types of pro se litigants: those who do their homework and those that lose. And if somebody doesn't come to us in the beginning and dig in and follow what we tell them in terms of the books to read and the rule books and do it, then they're not going to get anywhere. The system is complex, but lawyers don't learn the law just in law school. They learn it by going to CLE courses and elsewhere. I've taken 163 CLE courses, which is probably 10 times more than the average.
Right, but, then,
he's probably
but Rob, do you agree that if a pro se litigant does their homework, let's for the moment talk about a civil case, they can get the same quality of representation they're likely to get if they hire a lawyer, say, somewhere in the
Well, it
middle
depends
range?
on what we're talking about. If we're talking about a civil small claims case, if we're talking about a civil landlord-tenant case where the laws are fairly well codified and fairly well specified, then maybe
But
that
let's
might
go back
happen.
to our report at the beginning of the show about Pam Chevet, who's dealing with commercial litigation that she's stuck with because of the results of a divorce.
Very, very, very difficult. And I would say, of course, attorneys, they learn the law in the classroom, but they also learn something else. It's foundation and precedent, and that means that every piece of law is built on something else. And that's very, very important to know as well as procedure. But I want to say something about Pam, though. You look at Pam, she's a different kind of pro se litigant. She's a person who apparently has resources. You saw her talking about learning about the computer and things of that nature. We have a whole slew of
She
pro
says
se
she
people.
hasn't worked or done anything else in her life for 5 years, Rob. That's a big sacrifice.
Precisely. But we've got a whole slew of people that have never touched a computer, have no access to a computer or the research materials.
Not to agree with Rob, but Carl, it does seem to me that she has a pretty high level of skills. There must be an awful lot of people whose skills or own experience in the world of paper and literacy may not be high enough to do that. How do they defend themselves when they don't have the resources in terms of prosecuting a civil action?
Well, let's talk about Pam Chevet, one of her best students. When she came to us a couple days after a judge had decided against her, but before she had gotten the written decision, within the time, therefore, to get stuff on the record within the reconsideration period, so she would then have it for appeal. She sat your distance from me with tears running down her cheeks saying, I'm floundering. She dug in. She didn't know anything about computers. She had never used a computer. It comes back to those that dig in. It would be much better if they came in the beginning. I just got a typical one today, an email. The person's going all the way through the appellate system, lost, and now they want to know what else they can do to go to federal court. And my response to them was, you should have contacted us before you went to municipal court.
Professor Romberg, to what extent are judges or those who administer the court system sensitive to any imbalance that may be struck when you have a pro se litigant against a trained lawyer? And to what extent do either judges or the administrative systems that support the courts provide support for the pro se litigant to try to even at least the ability of people to make their case?
Well, it varies broadly. Some judges are very sympathetic, others are less so, and essentially hold the pro se litigant to the same standard as if he or she were represented by counsel. New Jersey, on the whole, I think, is relatively good and provides a reasonable amount of services. The website that Sandy King mentioned earlier provides a little bit of basic information so that litigants know the difference between a plaintiff and a defendant. But I think the occasional case where you have a obviously very intelligent woman who's devoted 5 years of her life to this litigation, she may well be providing effective representation to herself for the vast, vast majority of litigants.
But you would say that she probably looks like an anomaly. One other question, Professor. Is the law clear that a person has a right to represent themselves?
Yes, in the criminal context, under the Sixth Amendment, there's a right to represent yourself. In the civil context, it's more of an issue that in the vast majority of civil cases, you don't have the right to have an attorney represent you. But you certainly can always, if you wish, represent yourself. It may well not be wise if you have a choice.
Now, Rob, we've tried to focus up till now a little bit on civil law because that's probably where most pro se litigation takes place. But we got to talk about the hard question. Is there ever a circumstance where you think a criminal defendant is better off being a pro se litigant?
I've practiced for many years, double digits, and I can't tell you what that situation would be. And let me tell you something about criminal judges. Publicly, they support and when I say support, they certainly do everything they can do to make sure that a pro se litigant has everything he needs. But privately, I would get calls left and right. Is there anything that we can do to convince this defendant to have an attorney? Because they know that, particularly with criminal, there is a high scrutiny that goes on in the appellate world. And if there are things
any circumstance where you think a jury might be sympathetic to a pro se litigant in a criminal case, especially if the charge were nonviolent or a matter where sympathy might play a role?
You know, I think it could happen. I really do think it could happen, particularly if you have a very articulate defendant. And we've seen this also with...
I took advantage of our relationship to Louis with an area where I knew your position was pretty extreme and firm, at least pretty clear.
Yes.
Carl, is there ever a circumstance where you think a person is wise or making a good decision if they're a pro se litigant in a criminal context?
Well, I got falsely accused twice, and twice I prevailed in municipal court. And I had a judge who wouldn't back up my subpoenas, which were all served correctly on time for discovery
so you were
so you were
charged
let me just
in
finish.
municipal court with a quasi-criminal offense, and when you say subpoena, so the court did not reach out to help you?
No, by no means. In fact, I would say 4 out of 5 judges are systemically anti-pro se, and we can understand why, because most of the time, pro ses do not know what on-point case law is, etc. So the judges become at least subconsciously conditioned not to pay attention to the legal arguments.
Were you acquitted in both of those matters?
Yes, but as I was going to say, they wouldn't support the subpoena where it made the demand for the evidence from the store that had accused me of something, and I wanted the tapes, and they were hiding the tapes because the tapes would have shown that their security guards attacked me, and I never did take anything. I had to immediately file the appellate to the Superior Court on a municipal appeal within the 10 days.
Okay.
Within the 10 days, you have to know that.
Let me ask you this, Carl. You've taken 163 hours of CLE work. You've helped scores of people work their way through the process, so you're probably not a typical pro se litigant, even though you're not a lawyer. So I want to go back to, except for you or somebody who has had a special exposure to the justice system, do you think that even in municipal court, that it's wise for a person to represent themselves when faced with a quasi-criminal offense?
Often they can succeed, and we have a lot of people who do. It comes down to what is the particular charge, what is the evidence. If you bring your witnesses in, and most people don't realize you've got to bring your witnesses in. So we have to teach them the basics. You know, lay the foundation, have the linkage, have the person identify the evidence and testify to it. And then don't forget the move to have it accepted into evidence, because if it's not in the evidence, the judge is forced by the rules to ignore it.
Professor Romberg, let me ask you to comment on Carl's situation. The things he's talking about are pretty basic and fundamental. Subpoenaing witnesses, knowing to move things into evidence. How would a person who sought to represent themselves on a quasi-criminal matter in a municipal court where there may be no public defender, how do they do that? How do they learn those basics?
Well, I think they are fundamental. I'm not sure they're so basic. I think you're absolutely right that Carl's a special case. I think your question, though, is what can you do if you're forced to or wish to go pro se? If you wish to go pro se and have a choice, I think what you can do is reconsider. But assuming that you really want to go pro se or can't afford, what you need to do, Carl's absolutely right. You need to research. You need to learn those fundamental techniques. You need to learn how to enter evidence, how to cross-examine, what your opening statement can and can't
But at your
include.
clinic, do you school people and send them out on their own, or do you kind of monitor or have others monitor people through the process once they've come to you?
We do a range of things. The clinic that I run takes federal appellate cases for people who are informa pauperis, which is Latin for indigent, who can't afford an attorney, who would otherwise be pro se. The Court of Appeals, the Federal Court of Appeals, screens the cases for potential merit and refers them to us, assigns us as counsel. Other clinics we have, generally what we do is represent pro ses, some people who would otherwise be pro se. Sometimes we try to hold workshops to help people learn
Professor,
more about...
I'm down to my last minute. Can I ask you for a prediction about whether we're going to continue to see a growth in pro se litigation?
I think we will. I think part of it is that legal representation is so expensive and people can't afford it. And I think it's very important people who represent themselves do their homework and do what they can to come into court prepared.
Okay. Carl, you're dealing with this on a daily basis. Do you as well predict an increase given a continuation of economic trends?
Yes, and as a matter of fact, I think that the nice thing about New Jersey and the bar in New Jersey and the courts in New Jersey is they understand this. and they understand that people like us are providing a valuable service to the public and to the judges. Because if the papers are properly organized, it saves the judges a lot of effort trying to see what the person's saying.
Rob, a different question to you. As a critic, given the things that Carl is doing and that the professor is doing, are you sanguine that there's going to be more assistance made available to the growing number of pro se litigants? Or are we looking at something that is a blot on the criminal justice?
Not without a fundamental change in the law, because this is class-based, and as you have more people that have less and have to get services in the system, they need somewhere to turn to. None of the solutions we talked about today really addresses that.
Well, it's a fascinating subject. Thank you for all being with us. That's it for this edition of Due Process, but you'll want to join us again next week for yet another in-depth look at law and social justice. Till then, for Sandy King and all of us here, I'm Raymond Brown. Thanks for watching.
I like that question. Yes, I do. I think it would have been very different. I learned more in the first 3 months that I was an American pro se than I'd learned in the approximately 5 years my divorce went on with my lawyers filing my papers for me. And it certainly would have been different. I would have been there demanding, and I would have understood that there are time limits for this, because what happened was everything got dragged on, and then time for discovery was over. I didn't know there was a time limit. I didn't even know what a deposition was when I came here after $242,000 for a divorce. That's absurd. That's truly absurd. So, yeah, I think it would have been very different. Thank you for asking that question.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual,